Ajay Rab sir. So I will request our moderators to introduce sir, and then we'll listen to sir about arbitration study and practice. I know it is necessary and fundamental for all the participants, for all the law students. We are here. So without delaying anything, I will request our moderators to introduce sir. Thank you.
A very good afternoon and a warm welcome to the participants to the inaugural ceremony of Lloyd International Arbitration Advocacy Program. And now we welcome Dr. Ajay Rab sir. Sir is a partner at Rab and Rab Associates LLP, Dehradun, an adjunct professor at National University of Judicial Sciences, Kolkata, and a visiting professor at National School of India, University, Bangalore. Sir is also a national policy consultant at Lexidel, a policy firm with offices in US, Israel, and Netherlands. He is an alumnus of National Law School, India University. Sir has recently pursued his master's in law and business from the WHU Otto Besham School of Management. Sir has done his doctorate in international commercial arbitration from Bucharest Law School. He is a recipient of the 2013-14 Joachim Hirsch Fellowship Award for the Academic Excellence in International Students of the Bucharest WHO Masters of Law and Business. Dr. Rab has been an associate at Amarchand and Mangaldas and Suresh A. Shroff and Company, where he advised clients on both domestic and cross-border mergers, acquisitions, and private equity transactions. Sir has also served as the non-resident legal expert at Vidhi Center for Legal Policy, which is an independent think tank assisting legislative drafting and providing independent critical analysis of existing laws and policy with recommendations to the ministries in the Government of India, standing committees and agencies of the Parliament to improve the governance for the public good. Sir has an extensive profuse experience in drafting legislations, policies, and legal research. He had worked in inter alia, the Law Commission of India, Ministry of Defense and Ministry of Consumer Affairs, Government of India, and other state governments. He was a part of the drafting committee of legal reforms in Criminal Procedure Court, legal reforms for selection and recruitment of civil servants, and the drafting committee of Mysore and Karnataka universities. Sir is a member of the several international arbitration centers. He is an adjudicator at the prestigious William Service International Commercial Arbitration Moot, Vienna, and coaches the participants in the same. Sir has also authored several books, and his latest publication is The Drafting Contracts, The Basic Principles, which focuses on bridging the gap between the legal education and the real-world practice. Sir, we are honored to have you among us, and it's a privilege to have your insight on the study of arbitration and its practice. We welcome you, sir.
Thank you, Samriddhi. Just to confirm, you can hear me okay, and there's no lag because the connection here is not very stable.
Yes, sir, you're perfectly audible.
All right, so my apologies. I'm traveling. If there's a lot of background noise, I apologize in advance. So just before I begin, thank you for that rather elaborate introduction. I don't think I'm worthy of such an elaborate introduction. But nonetheless, we are here to talk about arbitration and advocacy. And the curious thing that I always find among students is that they think arbitration is different from advocacy. And arbitration is something different from courtroom litigation or litigation per se. And I don't blame you. I don't blame you because even our legislators have made the same mistake. If you see Section 89 of the CPC, they think arbitration, mediation, and conciliation is one and the same thing, right? And anything that is capable of settlement should be sent to arbitration. And it ultimately took Justice Ravindran in the AFCON judgment to say, look, boss, arbitration is not mediation and conciliation. It's just litigation. And it is litigation outside of court. That's it. There's nothing very diverse from it. So the first thing that I would tell you about arbitration study and practice is that if you don't know your CPC, if you don't know your Evidence Act, if you don't know your regular court procedures, you can't do arbitration. Because if you don't know what they are, how do you expect to not apply them in arbitration, right? The idea that, and this is a curious argument that comes up, I think, in virtually every arbitration in this country, at least seated here, is that Section 19 says the tribunal is not bound by the CPC and Evidence Act, which some people seem to read as shall not apply. But that's not what it says. It doesn't say the tribunal shall not apply the CPC and Evidence Act. It just says it shall not be bound by the CPC and Evidence Act, right? So the basic principles of CPC and Evidence Act virtually apply to every arbitration proceeding or any quasi-judicial or judicial proceeding. So whenever you think of studying arbitration, please don't think as it's some golden goose that, you know, will take you only to 5-star hotels and business class tickets and fancy arguments before the most learned arbitrators. That's not what arbitration is. All right. Arbitration is simply opting to choose your own procedure, your own judge, and a relaxed form of standard of evidence. All right. So, for example, and this is something fundamental. Under the CPC, you're supposed to provide the original document in order to prove your claim. All right. In arbitration, you can share a WhatsApp and that the tribunal will read. That's the difference. The reason commercial parties choose arbitration is because nobody keeps a record of everything original in today's world, especially online. And therefore, arbitration just makes more sense. All right. In order to study arbitration, I think the first starting point that I think every student has asked, and right from my time, we all ask is, which book can we read in India, right, to study arbitration? And the fact of the matter is that no book currently explains the concepts. They are more like a case compendium or a commentary meant for practitioners. All right. So if you really want to study arbitration, you should focus on this book by Margaret L. Moses. All right. And everybody likes to talk about Redfern and Hunter, but there's also a student edition of Redfern and Hunter. So please understand that these are your basic textbooks who will tell you what arbitration was supposed to be like. And only once you know what arbitration is supposed to be like, can you figure out the difference on what India has done to change what it was supposed to be like. You know, we've read 101 blogs, I think, by today, which say India is not pro-arbitration. Can any one of you tell me what does it mean to be pro-arbitration? Anyone? Just unmute yourself.
Shall I try, sir?
Yeah?
Can I? I'm Saurabh Karmakar, sir.
Yes, Saurabh, please.
Yes, sir. So as you said only, and as I also studied, I term it as a private adjudication that you said, that it's a kind of litigation and it's dealing litigation outside the court. So I define it with two terms as private adjudication. We have two kinds of settlement process, dispute resolution process that I know, that adjudication and settlement. But I rarely take it as a private adjudication process. So this is what.
But why private? Why not public?
Because of it involves private parties, and when yes,
as does a civil suit.
Yes, sir.
As does a civil suit. Even a civil suit involves private parties.
Yes, sir.
So what is so special about arbitration? You know, the reason I say this, Saurabh, is because everybody thinks of arbitration. You know, we have internships and job applications coming in. I want to do arbitration. I want to be an arbitrator. I have an interest in dispute resolution. And for the love of God, I don't know what that means.
So for me, sir, while I was studying, while I was fascinated towards arbitration, it's something it's not only the legal field, but we are moving towards an era for expertise. And we are like talking about dispute resolution process. Therefore, we also get this term that expert determination. And then when we are needing expert determination, we want to invest on our legal cost, on our legal proceeding. And I think that is why arbitration gets its most popularity, that it's a party autonomy thing, and their private parties can be involved more. They can use their party autonomy.
Let's be honest, Saurabh. Students are interested in arbitration because they think that will give them a better job, right? Where they learn more.
Yes.
Am I right or wrong? Let's just be honest.
No, sir, it was.
But the fact of the matter is, if I go to a civil court and ask my dispute to be decided, am I not asking the dispute to be resolved? I am, one way or the other, right? The reason why it's looked at as dispute resolution as opposed to litigation, or what we understand in common law as the adversarial system of adjudication, right? The distinction is that in arbitration, both parties are supposed to cooperate because both parties want a quick resolution. They want a decision. They don't want to be stuck at evidence, revision, review, appeal, second appeal, SLP. That's why arbitration. And that's why it's called dispute resolution as opposed to adversarial practice. All right. That's the real reason. So when you apply for internships and when you say that I want to be a dispute resolution lawyer, be clear about why. Because it's not that you can completely leave court aside, right? You still need to go to the court to get an arbitrator appointed. You still need to go to the court for interim measures. If you get an award, it becomes a decree. You still need enforcement. It can be set aside, all sorts of things. I think the problem that exists today is that many lawyers who call themselves arbitration practitioners tend to do more of arbitration related practice in court, which is your setting aside and interim measures and appointments. And before a tribunal is slightly a different ball game. There, the adversarial process does not matter, right? So you will not unnecessarily oppose. I'll give you an example. So I'm in the middle of a cross-examination right now, and because I could not say no to Saurav, I have taken a break for an hour and joined you, and I'll get back to that. And one of the remarks from the opposite counsel was that, Mr. Rab, you are not opposing me. And I said, why should I oppose you? You are cross-examining my witness. What you're asking is relevant. Why should I oppose you unnecessarily? But that's the way we've been trained, right? That in a civil court, even if the lawyer is asking the right question, you'll object just because you have to. And that's where arbitration differs, right? I want to get over with this so that we can decide the dispute and move on. Because the commercial costs of not having a decision are higher than me losing. All right. So when you study arbitration, please understand why parties choose it. What does it really mean by party autonomy? It means the flexibility to, now let's say, I want Ayush to decide a cryptocurrency dispute. Ayush may be the expert in cryptocurrency. But if Ayush is a district judge, the likelihood of him being an expert in cryptocurrency is very less. That's why I have the flexibility to pick the guy or the girl or the lady that I feel is going to be most learned about my dispute, right? And that's where arbitration comes from. When you think of arbitration as a career, again, and I repeat myself, if you don't know basic procedure like CPC, Evidence Act, you will never make a good arbitration practitioner or even an arbitrator. All right. There are certain procedures that have to be followed. Otherwise, you'll risk having an award which will be set aside. All right. A lot of people tend to believe that production of documents is this, we have these red fern schedules and all sorts of fancy terms floating around in arbitration. And if you think about it, where do they come from? They come from your basic procedures in the CPC asking you for production of documents, right? So please don't study arbitration in a vacuum. That's my request to you, right? Don't just think that, okay, I have picked up, Indu Malhotra on arbitration. Now I know everything in arbitration. That's not the way it works. You need to study every subject related to it. The contract law, the Transfer of Property Act does not apply differently in arbitration and differently in the civil court. The law remains the same. All right. One thing that I would tell you is that yes, arbitration moods help you learn arbitration a lot, because that's the first time you really apply arbitration knowledge. So if you have a chance to do any mood, take up any arbitration moods, you should, right? Because if you go to a law firm or a chamber and you're simply researching on case laws, you don't know why you're doing it. You don't know what's the end use of it. You don't know the facts. You don't know the client. You don't know anything. Some firms are very good. They tell you, they make you a part of the file, right? But obviously there are confidentiality concerns and many other issues. So I'm not judging anyone. All right. All I'm trying to say is that sometimes you might be lucky enough to know why you are researching on something, but most of the time you won't be. In a mood, you know why you're researching, where you're going to research, how you're going to research, where you're going to apply it, all those things. So when you think about arbitration study, and that's why I think this is the program on arbitration advocacy is a much needed step. And therefore I request all of you, including Saurav, to make sure that this message goes out there, that arbitration advocacy is also advocacy. It's not a unique creature sui generis by itself. If you're an advocate before a court, or if you're an advocate before the tribunal, you're an advocate. You are representing a client. It's just a manner of presentation. The methodology differs. And you need to know both methodologies before you can understand arbitration. Right? I expressed to Saurav that I'm hardly the person who can talk for an hour non-stop. So I'll be happy to take questions. And, I know several students want to ask so many things about arbitration. Will an LLM help me become an arbitration practitioner? All sorts of funny questions. Yes. Feel free to ask them. I think that will help you more than me talking about arbitration. But before you do, again, let me congratulate Lloyd as well as Saurav and everybody who's involved in this program. And when and if you materialize it to its full potential, you will realize that there is a dearth of arbitration education in this country. Everybody seems to be doing it. Everybody seems to be wanting to do it, but nobody knows how, right? And therefore there are so many of these online courses floating around, some workshops floating around, some certificates floating around, where everybody wants to learn, right? So I commend all of you again for this noble and much needed initiative. I hope that you frankly see the light of day that you have imagined. And if you do, I think it'll be a game changer for this country in terms of the education for arbitration. Please, over to you, Saurav and Smriti.
Thank you, sir. And first of all, I will say to all of my students that I have been fascinated towards arbitration, mostly on commercial arbitration, by seeing, sir. I had tried twice, like for internships at Sir's chamber, and I received the mail as well. But unfortunately, I could not join, sir. But this time, like I had this in my mind. If I had to call Sir Ajay sir, what will be the best topic? And this is what I have seen. Like I have noticing Sir's post and all. Like he has been the coach of NLSL Bangalore for Williams Series. I was being fascinated while I was doing in second year or I was in third year that I want to do Williams Series. And I want to go to Ajay sir after while doing internships. I will ask questions, sir, how I can be helped or something like that. But now, sir, this program, this Lloyd International Arbitration Advocacy Program, it is designed to promote and culture institutional arbitration advocacy. And when we are saying that, we include all the roles. It's not only it's a design of mooting. It's not a mooting. It's like here we have different roles like client will draft their problems, their disputes. And they had one boot camp, a primary knowledge that what are the disputes that can be referred to arbitration. And we had differentiated 5 subjects, and that is mostly required for our higher studies. Investment arbitration, commercial arbitration, sports arbitration, maritime arbitration, and energy arbitration. So we are also participating in a sports arbitration mood wherever I am ambassador of India. So this is our today is our final round, and we don't know the result what will be. So, but all these activities, small activities we are doing at Lloyd, and apart from all these competitions, we are going to launch this at national level and then international level. But before doing so, we want that it should be a prior model at our Lloyd, like at our campus with our students who had
हमारे
some
देन को
prior
लाइक देन को था
knowledge on arbitration, mediation, and negotiation. First, we'll eliminate them on a single case which could be referred in client counsel, and then the same case will be in mediation negotiation. First, amicable settlement, then it will be not settled, and then it will come to arbitration. So it will be our elimination round, sir. We need your blessings. And before going to the end of the topic, sir, I would request all of our students, if they have any queries, I might I will be happy to hand over to this moderator, to our moderators, that they will be welcoming questions if anyone has, or they can write on the chat box. So thank you, sir. Thank you, moderators. Thank you.
Thank you.
Thank you, sir, for your very insightful session. And now the forum is open for the participants. If they have any questions, kindly post it on the chat box or raise your hands. We'll be allowing you to speak. Yes, right. Usman.
Ahmed Usman. Yes.
Good afternoon, sir. Good afternoon, sir.
Good afternoon.
Yes, sir. So my question is that can you elaborate or describe the duties of an arbitrator? What are the duties that a good arbitrator should do?
Usman, could you please type it in the chat box? I think my connection is a bit low, so I'm not able to hear you properly. Can you just type it in the chat box?
If I may, sorry.
Sure, sir.
The question I can transfer, sir.
Yeah.
He's asking about the eligibility of an arbitrator.
Mm-hmm. What eligibility? What is a good arbitrator?
Yes, sir. While adjudicating, because he has to compete in the role like an arbitrator. That's why.
I think a good arbitrator is one who is inherently fair. All right. If you see Section 16 of the Arbitration Act or the Unset Trial Model Law, you will see this duty to be fair to both parties. All right. And a good arbitrator is one who gives equal opportunity to each party without prejudging anything and allows them a fair opportunity to present their case. Right. It goes without saying that an arbitrator should obviously know his or her law and should be well versed with the facts. But the point is that, you know, we have the habit of mimicking our judges in courts where we don't let the counsel speak and we start with the word dismissed even before they've opened their mouth. Right? That's not a good arbitrator. That if I can just draw an analogy to that, you'll understand now what I'm trying to say is that a good arbitrator will hear the person, ask questions that they genuinely want an answer to rather than just to show off their knowledge. Right? And I think that's what makes a good arbitrator. But at the end of the day, the party should feel, yes, I gave my best foot forward, and now the arbitrator will be fair and impartial and will give me a decision. Right? That's the answer. Yes, Muntazir Hussain.
Good afternoon, sir.
Yes, good afternoon.
Sir, it's a great honor for us to interact with you at this session, sir. Sir, I just have two questions. So my first question is, as an arbitrator, how do you deal with the arbitration process at the beginning? And sir, my second question is, what are the odds of winning an arbitration process?
What are the odds of winning an arbitration?
Yes, sir.
The odds of winning, and I'll answer the second question first. The odds of winning an arbitration are the same as the case merits, right? If you have a good case, you'll win. As simple as that. Right? If you breach the contract, you'll lose. The odds of winning an arbitration remain subject to case merits. Your first question, could you please repeat it?
So my question was, as an arbitrator, how do you deal with the process at the beginning?
Yes, at the process, the beginning. So, you know what happens actually, or what is supposed to happen, let me put it that way, is that once the notice of arbitration is received, the arbitrators actually call what is called a case management conference, right? It either happens on the phone or via Zoom or sometimes in person, but rarely in person in international arbitrations, where you fix up a schedule and you say that, okay, this is when the claim will be submitted, this is when the reply will be submitted, this is when the rejoinder will come, this is how production has to happen, how does filing have to take place, email, PDFs, searchable PDFs, double side, single side, more than 200 pages in an appendix, and that all that process is documented in a document called procedural order, right? In the courts we call it order sheets, right? In arbitration there are procedural orders, and procedural order number 1 is the most important because that lists out exactly what you are supposed to do in the arbitration.
Okay.
Right? And at that point, parties also say that we want only a documentary hearing, we don't want cross-examination and things like that.
Okay, sir. Thank you, sir.
Right. All right. Any other questions?
So there is a question in the chat box, if I may read.
Just a second. It's not showing up on my chat.
I'll read it, sir, for you.
Yeah.
So as you are a part of many key arbitration centers and you have such a professional experience as an arbitrator, can you tell us what is the most significant challenge that the arbitration sector is facing currently?
Oh, there are many challenges the arbitration sector is facing currently. One is that arbitration is squarely in India limited to the legal professionals, whether they are judges or senior counsels or lawyers. Arbitration was meant to be expert adjudication, which means, and there are many people that I have met who are chartered accountants, who are architects, who are engineers who do arbitration abroad, but those things have not come to India yet. The other problem is that because it's a legally heavy profession at this point, it's very heavily governed by the CPC and the Evidence Act. And that takes away from the goal of arbitration. Apart from that, I would say there are many legislative problems that continue to exist. But that's a whole can of worms, so I'm going to limit myself and not talk about those here. Yes, any other questions? I'm happy answering questions. I'm just reluctant to give gyan uselessly.
Good afternoon, sir.
Yes, Akshay.
Yes, sir. Sir, actually, I am a little confused while preparing the arguments because I have heard that in an arbitration, the arguments are more inclined towards argumenting on the facts instead of the laws, unlike the normal court proceedings. So, is that correct, or is there any other way we should prepare for arguments?
I'll tell you two things. One, it's partly correct and partly incorrect. It's partly correct because we are not creating precedent, right? There is no inclination on the tribunal to rule a particular way because of a precedent we want to create, right? Therefore, legal arguments, very fancy or policy-based arguments, don't make so much of sense in arbitration. I'm not saying they're completely irrelevant. I'm just saying that because you are not creating precedent, you don't look at the entire case from a policy angle. Your statement is incorrect to the extent that without law, what are facts? Nothing. I may have murdered you, but if it's not an offense, it's not an offense. Right? Similarly, in commercial transactions, if I didn't ship the goods to you in time, the question is, am I entitled to an excuse such as force majeure or not? And therefore, the law, you can't deal with facts without the law. Please remember that in arbitration or in any advocacy, the idea is to convince the person before whom you are appearing about why your client's rights have been violated or your client has not violated somebody else's rights. And that always will remain a mixed question of law and fact, right? So I wouldn't take that statement on its face as it is.
Thank you, sir.
Most welcome. All right. If if there are no other questions, then I will request you for your leave because I have to join back the cross-examination. And I will excuse myself and apologize for leaving early. But like I said, I couldn't have turned down Saurav's very kind invitation. And therefore, I tried to make the best of both worlds. Right? Any last closing questions? I'll be happy to take one and then take your leave.
So I think we'll call it a day.
So is there any question?
All right. Thank you, sir, Samriddhi and Saurav, and thank you everyone for your time. And hopefully we'll do this when I'm not in a hurry someday. Yes.
Thank you, sir. Thank you for the short notice and you joined.
All right, and I wish you a lot of luck. I think one of the reasons I couldn't say no also, Saurav, is because I genuinely believe what you're doing is good, right? And I hope you take it forward. All right.
Yes.
My best wishes to all of you. Thank you.
Thank you. Thank you.
Thank you.
So now we are moving forward to our next guest speaker. That will be Ananya Pratap Singh sir, and he will be talking on the topic of enforceability of arbitral awards in Indian courts. So he will be joining with us at 2:30. Till then, if you have any doubts or query regarding leave or any questions related to your participation role or responsibility, you can ask, and then if not, then we'll move forward with a short break for 10 minutes, and then we'll join by 2:10 or 2:20. But we don't need to go out of this meeting. We'll be in this meeting, and we can turn off the camera and we can take relax. Thank you.
Ja. Okay, super, super.
I request everyone to switch on their camera. Uh, we are going to begin our last session with Ananda Pratap Singh sir by 2:30. So I will request everyone to switch on their camera and wait for next 3 minutes. Thank you. So we are moving forward to welcome our next speaker, Mr. Anand Pratap Singh sir. So he is a guest professor at Lloyd Law College, and he will be joining soon. I will be requesting our moderators if they welcome sir with an introduction speech, and then we'll move forward to this topic, and then we'll be next welcoming Tariq sir, and we'll be also knowing about leave and also the elimination round. So I will request everyone to please have some patience and switch on your camera. And if any question around any topic, please write it on the chat box, or you can convey to our moderators. They will convey to the speakers. Thank you. And finally, I'm requesting everyone, please switch on their camera. Abhijit Singh, switch on your camera. Again, I am welcoming all the participants for the next topic and next guest speaker. I will request our moderators to introduce Ananya sir. Ananya sir has already joined the meeting. So I kindly request our moderators to introduce Ananya sir to all the participants. Thank you.
I hope I'm audible to everyone. So now we welcome Mr. Ananya Pratap Singh. Sir is an advocate, arbitrator, and academician currently based in New Delhi, India. He was awarded the member grade by the Chartered Institute of Arbitrators and the Singapore Institute of Arbitrators in 2018. He has also pursued and passed the Fellowship Assessment Course examination organized by the Singapore Institute of Arbitrators in 2018. Currently, he is on the resource panel of the education community of the Singapore Institute of Arbitrators. In addition, he regularly sits as an arbitrator and coaches team in leading international moot court competitions such as William Seavis International Commercial Arbitration Moot, Foreign Direct Investment International Arbitration Moots, and the likes. He is also a PhD student in International Commercial Arbitration at the Faculty of Law, University of Colombo, Sri Lanka, under the supervision of Dr. Lawrence Poo and Dr. Delini Patharana. He holds an LLM from the National University of Singapore and East China University of Political Science and Law in International Business Laws. He was called to the Bar Council of India in 2017 and to the Bar Council of Delhi, India in 2016. In addition to his practice of law, he teaches the modules of international commercial arbitration and insurance law to the students at Lloyd Law College, India. He also runs his own blog where he provides insightful case updates primarily in the field of international commercial arbitration from India, Singapore, and the UK. His areas of practice includes advising and representing the clients primarily in the area of international commercial arbitration, insurance, reinsurance law, maritime law, including the marine insurance, maritime arbitration, international sale of goods carried by sea, carrier's liability, product liability laws, international trade laws, and taxation laws. He also holds the experience of advising the clients in matters related to the insolvency and bankruptcy laws, intellectual property laws, gaming laws, information and technology laws, and providing secretarial, regulatory, and compliance-related services to the clients in these fields. His work experience includes working with CSL Chambers, an associate firm of Clyde and Corporation in India, and with John Wilson Partners Sri Lanka, in addition to several internships divided into litigation chambers of judge, senior counsels, and full service corporate, commercial, IP, and litigation law firms in India and in Singapore. We, from Lloyd Alternative Dispute Resolution Center, welcome Sir for a guest speech on the informants of arbitral awards in Indian courts.
Thank you, Simra, and thank you all the Lloydians. It's a very good afternoon to everyone, and I believe I'm a familiar face in the campus now. It's been almost a year teaching Lloydians. So today I'll be dealing with the aspect of enforcement of domestic awards primarily, but I believe that most of you have not dealt with or might not have read the Arbitration and Conciliation Act in detail or in that sort of minute details. So I will be just briefly touching upon how it works and how are the nuances and what are the nitty-gritties of enforcement of an award in India. So domestic awards. So see, I will go with a very layman perspective, like how arbitration works and what is an award. So award is basically an outcome of the arbitration. Arbitration is a private dispute resolution mechanism whereby a party has been directed to do or not to do certain aspects. Okay, it's just like a decree of the court. Okay, now say for example, you have been awarded or you have been granted a decree by the court. But how will you get the fruits of it? Like how will you say that, for example, a court of Gautam Budh Nagar has granted 5 lakh rupees to A against B. Now, how will he get 5 lakh rupees? So that sort of proceedings are called enforcement proceedings. enforcing that decree that has been passed in favor of A. Just like a decree, similarly, an arbitral award is also enforced. The only, I would say, impediment in enforcement of an award is it comes out of a private dispute resolution mechanism. It does not have like per se sanctity of the court, but at the same time, due to provisions of the Arbitration Act, now an award is deemed to be a decree of a civil court. Okay. Now, supposedly there was an arbitration going on between two parties, A and B, both being Indians. Okay, right now we are only talking about a domestic arbitration. Now, don't get confused with what is domestic, what is international, and what is foreign arbitration, because that's a separate issue altogether. Right now, we are just briefly touching upon how the enforcement of award takes place in India. Okay, whatever questions you have, we will discuss later on in the last. Okay. Now, supposedly there were two people, two Indians, A and B. They got into arbitration. The arbitration has commenced. Everything has happened. Parties have submitted their respective pleadings, and an award came out of this arbitration. Okay. Now, this arbitral award was passed in favor of A, and A wants to enforce this award against B. Now, the question arises: where should I file these enforcement proceedings? Against whom should I file these proceedings? And what is the procedure of filing these proceedings? Okay, so all these aspects are dealt with mostly under section 35 and 36 of the Arbitration and Conciliation Act. See, I won't go section wise over here. I'm just very briefly telling you how it goes. First of all, then if in order to file an enforcement proceedings, in order to file an application seeking enforcement of an award, there is a prerequisite. What is the prerequisite? Now, award has been passed. A has won the case. Award has been passed in A's favor, but B has certain grievances. B is saying, okay, what has been granted in the arbitral award is not agreeable to me. I have objections. There are certain objections that I have against the award. What should I do? Then Arbitration Act provides section 34 remedy. What is section 34? Section 34 says that an award can be set aside on these limited grounds. And why I'm talking about this? Because section 36, which is the enforcement proceedings, can only happen once the time to file a section 34 application has lapsed. Meaning thereby, once B's right to challenge the award passed in A favor has lapsed, which is 3 months, then only A can file an enforcement or execution of the domestic award. This much is clear. Very simple. A wants to file execution enforcement of the award. That will only happen once the 3-month period, which is granted in section 34 to challenge, so-called challenge, it's not challenge, but okay, so-called challenge the award has lapsed. Okay, this requisite is done. Now, before that, I have asked you, I have asked the question to myself, against whom this award can be enforced. Sorry. Oh, is there a question? Okay. So against whom this award can be enforced? Yeah. So basically there have been line of judgments wherein it has been debated at length whether a third party, I will tell you what is the relevance of this question, whether a third party or a non-signatory can enforce or an award can be enforced against a third party or non-signatory. I'll tell you, I'll explain all these terms might be a bit technical for you, but who is a non-signatory? A non-signatory is a person who has not signed the arbitration agreement, but it is a relevant party to the arbitration. How? Say, for example, there's an arbitration going on between A and B, and B has a group of companies which has B1, B2 as well in the same group. So B is like the parent company of B1 and B2. Now, arbitration agreement has been signed between A and B, so the signatories are A and B. And non-signatory will be B1 and B2. Now, the Arbitration Act says that the award is enforceable to any person claiming an under through the parties. This is given in section 35. Now, you might be understanding the relevance of why I talked about all this aspect. Meaning thereby, if it has been satisfied by if it has been satisfied by A, that B1 and B2 have entered into a contract through B, even though they have not signed the contract, even though they have not signed the arbitration agreement, they were not parties to the agreement. but they are person claiming through and under the parties of the Arbitration Act, which is A and B, being subsidiaries. So the award will be enforceable against B1 and B2 as well. Meaning thereby, if B is not able to pay or B is saying that I'm not liable to pay, A can go against B1 and B2 as well because of this section 35, which says that an award, once it is final, is enforceable against person claiming or under through it. Now, the thing is, this is not as simple as it might appear, okay? Because the thing is, you might have seen the structure of Tata's, of Reliance, or you can take example of any conglomerate. They have subsidiaries after subsidiaries after subsidiaries after subsidiaries. They have different intentions to have that sort of structure. But what I'm telling you is, this is not very easy to decipher that whether an award can be enforceable against each and every subsidiary of a parent company or vice versa. So in order to determine whether a particular award can be enforceable against a third party, in our example, the non-signatory third party was B1 and B2. In order to decide whether it can be enforced against non-signatory, there's a very beautiful doctrine which has been which has passed the muster of Indian courts now as well. That is called doctrine of group companies. Now, what is doctrine of group companies? It simply means this, that you will pierce the corporate veil. If you pierce the corporate veil means this, that you will see what was the intentions of the party while entering into the arbitration agreement. If the parties have really intended that, okay, when A and B entered into a contract, if they have intended that B1 and B2 will also be parties to this arbitration agreement, or say, for example, B has entered into a contract for supply of certain goods which needs to be provided by B1 and B2, and B has given a representation or an apprehension to A that, okay, we are entering into this contract as a group, meaning thereby this will suffice that there was an intention between the parties to make third party or non-signatory party to the arbitration agreement. And once that third party, applying this doctrine, once that third party is successfully determined to be a proper party to the arbitration agreement, the resultant arbitral award will also be enforceable against this party. Now, again, I will tell you, there are settled principles, there are line of judgment, like you will see the best judgment you can read on this is Chlorocontrol, which talks about this doctrine and how this doctrine will work. It's not normal, it's not general, rather it's an exception. A non-signatory can only be made party to the arbitration in only exceptional circumstances where it is crystal clear that parties have intended to do so. Otherwise, it cannot happen. Why? Because there's another doctrine which comes into picture in arbitration, which is very prominent doctrine, which is doctrine of party autonomy, which simply means that nothing can go beyond the layout of party autonomy, parties' freedom, what parties have agreed. And if they have agreed that, okay, A and B will only be parties to the arbitration agreement, they cannot go beyond that. So why I'm telling you all this? Because it is relevant to answer the question, against whom should I enforce this award? Now, I give you a classic example. Say, for example, A had entered into a contract with, say, B, and B is a group of companies. Okay. Now, B has shown this intention that B1 or B2, both the entities, will be in tandem or will be working together, and we are together a group of companies. Now, say, for example, A wants to invoke an arbitration clause, and the dispute is between B1 and A. So against which party should I file the Section 11 application, which is appointment for an arbitrator? Where should I file enforcement of award? Say, for example, B is a defunct company, it does not have assets only, and you have an award in your favor. A has an award in his favor. B does not have any assets. B2 does not have any assets. B1 has assets. Now, if I can prove that because of group of companies doctrine, I can directly make a non-signatory party to the arbitration, I can enforce an award against that company. And am I making sense? So what I'm saying is, this doctrine attains relevance because it is important to know against whom I should enforce my award. Because in a structure, in a conglomerate, it very well happens that some of the companies do not have assets. They are just shell companies. So in order to find out whether I am enforcing my award against the proper relevant entity, it is important to see whether that award is enforceable against the judgment debtor. And that is what section 35 enumerates. Okay, now I have decided I will enforce my award against B1. Next question arises, where should I file this application? Now there is an application that needs to be made. Supposedly the time which is provided in section 34 to challenge the award is done, over, 3 months over. Now I want to file this application against B1. Where should I file? For this purpose, we will go to section 21E of the Arbitration Act, which prescribes the definition of court, which has gone through a lot of judicial interpretation. When you do a module on arbitration, you will get to know that how many judgments it took to finally come to a conclusion. But basically just understand. So for example, I want to enforce this award against B1. Now B1 has all its assets in Delhi. Okay, B1 has all its assets in Delhi. Will it be relevant for me to file this application in Bombay? No, because the assets are in Delhi. The relevant court appropriately should be the courts in Delhi, who will have the relevant territorial jurisdiction in order to give me the requisite remedy. Now, for example, I am seeking attachment of those properties of B1. Now, Bombay court will not be appropriate to give me that decree. That can only be made through a Delhi court. Now, one more aspect that need to be clear is an award, an arbitral award under section 35 is enforced as a decree of the court. This is not as simple as it might appear. It simply means this, that all the provisions of civil procedure code, which are applicable to enforce or execute a decree of the court, are applied in toto for enforcement or execution of an arbitral award in India. Okay, because of that, the relevant court becomes an important factor. Where will you file this application? Now, after much of deliberations, after much of contradictory judgments from high courts, Supreme Court recently come up with, not recently, but Supreme Court came up in 2020-21 came up with a judgment wherein they have said that wherever the assets of the judgment debtor, the award debtor is someone who lost the arbitration. So award, basically wherever the assets of the judgment debtor are located, the courts which have jurisdiction to that assets will be the relevant court for applying or filing an application for execution of the award. This much is clear. Okay. Now we come to section 36, which is enforcement of an award. Now, the thing is, there is a bit of history behind section 36. It was not as good as it appears now. Okay, Ojaswa, can you please mute yourself? I'll be grateful. Yeah, so basically section 36 is the provision which is the charging section which deals with enforcement of award in India. So earlier what used to happen, as I told you, there is something called section 34 application, which is like filing objections against the award. As soon as that application was filed, it used to happen before 2015. So as soon as that application is filed by the judgment debtor who has lost, timing, just understand, a person who has lost the arbitration files section 34 application, even though it is not a general norm, but assume just for the sake of, understanding. As soon as the section 34 application objecting the award is filed, there was an automatic stay on the enforcement. Now, what does it mean? It simply means this. Till the time section 34 objections have not been decided, meaning thereby till the time the court has not disposed of or has not decided whether the award is, should be set aside or not, it cannot be enforced. And this used to go against the very ethos of arbitration, because I am A, I have an award in my favor, but just because B has filed an application under section 34, I am not able to get the fruits of my award. Why? Because there is an automatic stay. Now, what is the automatic stay? It means that once a section 34 objections has been filed by B, I cannot enforce my award. Now, the Supreme Court in 2020 understood, after a long deliberation, they have understood this point that this cannot be the case. The automatic stay cannot be the case. And let me tell you, this was not given in the section. This was because of practice. All the courts were practicing in such a manner that, okay, 34 has been filed, objections have been filed against the award. It cannot be enforced because first we have to go through the objection stage. Now, Supreme Court came up with a judgment and they have clarified that there cannot be an automatic stay, which means that now in order to file a section 36 application, in order to get us, now what is a stay? Just understand what is a stay. When there is an enforcement proceeding going on, say for example, you have filed an application for enforcement of an award, that will go on for some time, right? But in the meantime, the other party wants that award to be stayed, which means it cannot be bring into effect for the time being. It's an injunction, type of injunction. It's a remedy which says that, okay, the court grant me stay of enforcement of this award, meaning thereby, for the time being, the court grants me the stay, the fruits of the award cannot be reaped by the awarded. Okay. Now, previously, what used to happen, as soon as the Section 34 objection has been filed, there was an automatic stay. Now, after the amendment, the Arbitration and Conciliation Act says you have to file a separate application, which is filed with Section 36 in order to get that stay of enforcement of the award. This is a big relief. This is a big relief because now there is no longer an automatic stay on the enforcement of the award. Okay. Now there are certain aspects, as I told you, there are certain prerequisites for an award to get enforced. First of all, the time limit which is prescribed in the Section 34 to file an objection needs to be done away, needs to be lapsed. Second is that if you want a stay of enforcement of the award, then stay will be granted as per the stay granted for the enforcement of the decrees in Civil Procedure Code. Now, this could be a bit difficult for you to understand. Just simply understand this. Whenever there is an enforcement proceeding filed for any decree under CPC also, there are certain powers granted to the courts, which is in the form of deposit, asking for a deposit or security. I'm talking about money decree, okay? What is security? What is deposit? It simply means this. You want to challenge the enforcement. You want to have a stay of the award. Okay, we are giving you. You deposit this much amount of award. What it means is this. If a decree of 10 lakh rupees is passed in favor of A against B, the court is saying, I am ready to give you stay of enforcement. You give me 50% of, you deposit 50% of 10 lakh rupees in the court in fixed deposit. Okay. Now, this is relevant because to make sure that there are no frivolous applications of stay being filed in order to prolong the litigation, in order to prolong the arbitration procedure, which is against the very objective of arbitration. Okay. So say, for example, B wants to get a stay on the enforcement of award, which A wants to enforce, then he can very well get it. But he will have to satisfy the court as to why security deposit or some kind of deposit should not be asked for by the court against him. Now, these are certain prerequisites in order to get the stay on the enforcement of award. Now, there is a recent amendment that has been brought in Section 221 in Arbitration Act in 2021, which goes one step ahead. Now, the thing is, stay can be granted in exceptional circumstances and subject to deposition of this deposit or security amount of certain amount of arbitral award which is granted. But in certain exceptional circumstances, this stay cannot be granted at all. These are the two conditions which are inserted by way of 2021 Amendment Act in the Arbitration and Conciliation Act. What does it say? It says that if the arbitral agreement which is basis of the award has been is tainted with fraud or the making of the award. So arbitration agreement or making of the award is tainted with fraud, then there could not be any stay on the enforcement of it. This is what Section 2021, this is what the insertion, that amendment that has been brought in the Arbitration Act says. Apart from that, there are other, now the thing is, what can happen in Section 36 proceeding? Now, you have found appropriate party against whom you want to enforce the award. You have found the appropriate court against whom you want to file this application. You understood the procedure, how to file a Section 36 application. Now, next question arises, what can a court do in Section 36 proceedings? What is the ambit or what is the jurisdiction of a court while deciding Section 36 application? Now, please appreciate the fact that Section 36 application or enforcement of the award happens once it has passed the muster of Section 34, which is like objection stage. This is very important because objection stage itself is a very vast stage which has a number of grounds on which an award can be set aside. And if that stage is gone, there should not be much of intervention by the court in Section 36, meaning hereby what 36 is doing is it is stamping the enforcement of the award. There is nothing much left in the court to do in Section 36 proceeding. Some things which a court cannot do in Section 36 proceedings is they cannot go behind the decree, meaning thereby they cannot go behind the award. What does it mean? It simply means this. If a certain amount of money has been granted or if a certain amount of interest has been awarded on the award, the court cannot change it. The court should not change it. It simply means the court cannot redraft or rewrite the arbitral award for the parties. They cannot do so. Now, we have talked about Now, there is a significant change that happened in 2015. Those people who follow arbitration, they must have seen that 2015 was a very important year when we talk about history of Arbitration Conciliation Act in India, because that has come up with remarkably a lot of significant amendments in the 1996 Amendment Arbitration Act. One of the provisions, like what was the effective date from which these provisions were brought into effect, was 23rd October 2015. Now, since Section 36 was also, which talks about enforcement of the award, was also amended by 2015 Amendment Act, the question that arises whether the arbitration which has commenced before this date will also be a part of this amended Section 36. Okay, let's break it down. It simply means this. If you have filed an arbitration enforcement of arbitral award proceedings before this date, that is 23rd October 2015, can you have the benefits of the amended Section 36 Act? The answer is yes. The court said yes, you can, because it's a procedural right. It's a procedural aspect. What Section 36 talks about is a procedural aspect, meaning thereby Section 36, which stands as of now, will be applicable on all the arbitration, irrespective of the fact that whether they have commenced before this date or after this date. Okay. Now, there are certain aspects which are usually discussed, or which usually comes in Section 36 proceedings, which are basically what happens that these the party who has lost the Section 36 application starts arguing the case again afresh, meaning thereby they start arguing that okay, an award is not enforceable because of these certain grounds. Now, there is a remedy if you lost a Section 34 application, which is by way of an appeal under Section 37. However, in Section 36 proceeding, now I'll ask you an interesting question. So, for example, the other parties, for example, B has not even filed objection under 34. He's saying, okay, the award has been passed. I have no objections to that. 90 days period in order to file the Section 34 application is also over. Now what you will do? You will file an enforcement of the award application. Okay. Now, for example, B files objections, and those objections have not been upheld. They have been held that, okay, what you are arguing, B is saying objections. These objections are not sustainable. We are upholding the award. What is the remedy that B have? The remedy is that B can file an appeal, which is provision which is given in the Section 37 of the Act. But till the time this appeal is filed and before this 3-month period of filing Section 34 has lapsed, there is a period in which you can file enforcement of the award proceedings also. Now, there is a Section 5 in the Arbitration Act which says that there has to be minimum judicial intervention of in the arbitration proceedings, which means that a judicial body, unless and until it is very imminently required, should not interfere in the process of arbitration, which includes Section 34 and Section 36 proceedings and 37 proceedings as well. Which means that once the award has attained finality, which is there in Section 35, which means it has attained, it is deemed to be a decree of the court, it should not be disturbed by the judicial intervention. This is what it says. Okay, now there are certain provisions of CPC which are applied when we talk about enforcement of decree, enforcement of award. Why is it so? Because as I told you that award is enforced as a deemed decree under the civil procedure codes, meaning thereby the stay aspects, the security aspects, and enforcement of decree aspects, all the aspects of a civil decree which are dealt with in CPC are in toto applicable to any money decree which becomes enforceable by way of a domestic award. And all those disclosures or annexures or whatever that needs to be filed in a civil decree for its enforcement are also applicable similarly and for the enforcement of a domestic award. Okay, so this is basically, there is another provision which is Section 42, which sometimes creates some sort of illusion or some type of confusion in the minds of parties. Why so? Because Section 42 of the Arbitration Act says that, okay, if there is judicial proceeding if there is any application that has been filed in one of the courts, then, and there are more than one court which has the appropriate jurisdiction, then the court which is first seized of the authority will be the appropriate court. Now, let me give you one example, you will understand better. Say, for example, there is an application that has been filed before the Delhi High Court under Section 11 for the appointment of the arbitrator. Okay. Now, there is another application which is Section 9, which is for the interim measures by the court, which is filed before the Bombay High Court. But the important aspect is that Section 11 application was filed before filing of Section 9 petition before the Bombay High Court. So Section 42 says that the court which is seized of the matter first, which is the Delhi High Court, will be the relevant court for all other purposes. Okay. Now, the thing is, just now I told you the appropriate court for the purposes of Section 36 will be the court wherein the assets of the judgment debtor are located. Okay. Now, say, for example, all the proceedings of the award happened in Bombay, but all the assets of a company, the company which has lost, are located in Delhi. So the question arises, where will you file the application for enforcement of the award, in Delhi or Bombay? Because as per Section 42, the appropriate court will be Bombay, because Bombay is the first court which is seized of the jurisdiction. And if we go by what I just told you about Section 36 is, you will file the application for enforcement where the assets of the judgment debtor are located, then it should be Delhi. So this aspect has been dealt with by the Supreme Court in a judgment wherein they have clarified that Section 42 is not applicable when it comes to Section 36 proceedings, meaning thereby that if there is an enforcement of the award, once the award has passed, the tribunal becomes ex ipso facto, meaning thereby they do not have any mandate now. The arbitration is almost over. Effectively it is over. So Section 42 cannot apply. Section 42 will only apply in a scenario where there's still an existing arbitration going on. Whereas Section 36 is a post finalization of the award, and that is why 42 will not be applicable in the enforcement of award proceedings. Okay, now this is basically what you should know about how the enforcement and execution of the award takes place before our Indian courts, the domestic award. Now there are certain disputed aspects that are there when we talk about enforcement of foreign awards in India, which I don't think is the just like the domestic award, the foreign award is also defined. So we have a separate definition of a foreign award, which is given in Section 44 itself, and which also defines the appropriate court wherein the enforcement of a foreign award application can be filed. Enforcement of a foreign award also happen in a similar manner as the domestic award, but the entire regime is totally different. I'll tell you why. The reason being that the enforcement, that when we talk about Section 36, we talk about the challenges, the enforcement and execution of the award, the domestic award. Whereas when we talk about enforcement of a foreign award, we talk about recognition. And there's a difference between recognition and enforcement. And to understand this difference, we need to see the parent, the founding instruments of the modern day arbitration, which is model law and New York Convention. So because of the New York Convention, Part 2 of the Arbitration Act, also known as the Enforcement of Foreign Award New York Convention Award regime. Why so? Because being a signatory to the New York Convention, we can only either recognize or not recognize a foreign award. Now, there are certain confusions on what is a foreign award, what is a domestic award, and what is International Commercial Arbitration Award, or an award which is coming out of an international commercial arbitration. Now, this aspect is something which has been into deliberation and arguments by legal in legal fraternity for more than a decade. But to tell you in very simple terms, what it means is simply this. Part 1, Section 36, Section 35 that we talked about right now is domestic award. And domestic award does not mean that it cannot be an international commercial arbitration. So domestic arbitration and international commercial arbitration are distinct, but international commercial arbitration and foreign arbitration are not synonymous. Okay, international commercial arbitration has been defined in the Act, and it simply means that certain origins or domiciles of the parties will be taken into consideration in order to decide whether the arbitration is international or not. Meaning thereby, it simply means this. If A, being an Indian, entering into an arbitration with B, Singaporean, then because of this definition of the international commercial arbitration, such arbitration will be international commercial arbitration, just because B is of another domicile. There are certain other aspects also which are taken into consideration in order to decide whether it's an international commercial arbitration or not. Okay, this is international commercial arbitration. Okay, whereas foreign arbitration is simply the arbitration where the seat of arbitration or the place of arbitration is outside India. And in such kind of arbitrations, Part 1, meaning thereby 35, 36 will not apply. Such kind of awards which are passed in foreign arbitration will be foreign awards for which we have a separate regime, which is Part 2 of the Arbitration Act, which we also call New York Convention awards. And that is why we only recognize them. There is no mechanism of enforcement or anything. We only recognize them because we are signatory to the New York Convention. Now, as I told you, there are three things: domestic arbitration, international commercial arbitration, and foreign arbitration. Foreign awards culminate out of foreign arbitrations. Now, let's discuss about international commercial arbitration, domestic and simple. So, if the arbitration is happening in India between two Indians, it's a simple arbitration. And if there is an arbitration happening in India between an Indian and a non-Indian, then it will be an international commercial arbitration, but domestic arbitration. Simple. It sounds simple, but when you have to apply your mind, because this can be a fulcrum, this can be an issue of dispute to a number of question that arises at the enforcement time. Now, we have talked about foreign awards, we have talked about their enforcement. How does it happen? There are similar grounds that are provided in Section 48, wherein you can resist the enforcement of an award, of a foreign award in India, like public policy, like other aspects. There are certain grounds which are given Section 48. The appropriate code, now again, the question arises, which will be the appropriate code? So, for example, an LCIA award or Singapore Seated Award brought in India for enforcement. Okay. Now, this Indian company has its registered office in Delhi also. It has its, other office or, branch office in Bombay. Now, if we apply CPC, CPC says that, okay, even branch office can confer jurisdiction, or certain other type of, offices can confer jurisdiction on a particular court. That can happen, but CPC will not apply. For section 47, for the enforcement of the foreign award, wherever the assets of the debtor are located, the courts will have jurisdiction. Meaning thereby, say for example, I have a foreign award of 10 lakh rupees, and the judgment debtor or the award debtor has assets in 5 different courts in India, in 5 different jurisdictions in India. Like for example, it has 2 lakh of assets in 5 different jurisdictions, then I can very well file 5 separate applications in 5 jurisdictions. This culminates out of the New York Convention and model law, which says that a person who wins the award creditor has the right to file in multiple forums. This cannot be seen as forum shopping. That is not the case. He is just trying to satisfy his award. And in order to do so, he has the right to file application in multiple jurisdictions wherever the assets of the judgment debtor are located. So, for example, in the same scenario, the Singaporean party can file an enforcement proceeding in India as well as in London. If the judgment debtors assets are located in London, he can very well have similar proceedings going on in 2 forums, because that is the beauty of New York Convention and model law. And similar sort of thing applies in domestic arbitration as well, but in part 1, not in part. Okay. Now we have talked about section 48. How can you resist the recognition of a foreign award in India? We talked about relevant court also. Security procedure also applies there as well. There are certain norms to that. But I would say there are only few sections which really deal with enforcement of a foreign award in India, and it's a separate regime altogether. Right now, we are only discussing about domestic awards. We have only discussed section 35 and 36, which I have been to question. I'm assuming you people must be having a lot of questions if you have listened to my, I would say, speech. So I'm open for questions. You can ask me questions.
Thank you so much, sir. Thank you for sharing your knowledge. Yes, sir, you can take over.
Yes. First of all, thank you, sir. Thank you for joining with us. So this is the event we are discussing in last 3-4 months, that we are coming up with an event which promotes and which cultures institutional arbitration and advocacy practice. So from the beginning,
I think we have some connectivity issues with the. Let me check. Just a minute, sir.
Meanwhile, if anyone has any questions, you can ask.
So I will now request all the students, if you have any doubt or question, please you allowed to ask such questions. And thank you, sir. Thank you for that.
Good afternoon, sir.
Yes.
Sir, I have a question with regard to, let's suppose if the liability has been mentioned in the arbitration clause itself, but the parties have adhered to to certain rules, let's suppose Hague rules. So which would be given primemost importance, the clauses which are mentioned in the arbitration agreement, or the rules that they have adhered to?
So see, Ashutosh, is a very good question, and this falls in the regime of conflict of laws issues. So basically what you are saying is, There is a conflict going on between two applicable laws. Let me tell this aspect to other people as well, because I don't know whether they are familiar about this aspect or not. What Ashutosh is saying, let's say, for example, in the arbitration clause, the parties have agreed
Sir, we can't hear you actually. I think there's some connection issue from your end. I think there's a glitch from Sir's end, so let's wait for him. He might rejoin soon. Meanwhile, if you have any questions, you can drop your questions in the chat box and your questions will be addressed.
Hi, Shimra. Actually, I lost my connectivity. Can you hear me?
Yeah, sir, you're audible to us.
Yeah, sorry, Ashutosh, the question that you have asked. So I was explaining what he has asked. So basically, what he's asking if there is a conflict between two type of law that are applicable. So for example, the parties have agreed in their arbitration clause that certain kind of damages cannot be avoided.
Excuse me, sir. Excuse me, sir. Sir, you are not actually clearly audible. Like we can hear you, but there's some background noise. Sir, you're not audible. Sir, actually, there's some background noise.
Let me try. You?
Yes, sir, you are audible.
Finally. See, Ashutosh, you have asked the question. Even the connectivity got disturbed. Okay, so basically Ashutosh was asking a question wherein he said that okay, parties have agreed in their arbitration clause that certain kind of disputes cannot be claimed, or certain kind of, say for example, they have agreed that punitive damages cannot be awarded in arbitration. Okay, but say for example, they have also agreed that arbitration will be as per CEAC rules, and CEAC rules or Hague rules provide these powers to the arbitrator. Then which law will prevail? The CEAC rules will prevail, or the agreement between the parties in the arbitration clause will prevail. This is what your question was. Ashutosh is still there or he left?
Yes, sir. Yes, sir.
This is what your question was, right?
Yes, sir.
Yeah. So see, the thing is, this is called conflict of law situation, and this happens quite a lot because there are like more than 4 or 5 laws which are applicable in a particular arbitration, lex arbitra, lex situs, lex contractus, and all. In such kind of scenarios, we usually have a conflict of law provision which says that in case of any conflict on conflict, if there is a conflict of laws, then this law will prevail, or this type of law will prevail. On the other side, in order to make sure that the award is not become unenforceable, the arbitrator will try to find a harmonious construction, which means that they will try to find a middle path, meaning thereby they will not award exemplary damages, understanding the fact that in some certain jurisdiction, exemplary awards are not enforceable, or they will not want to get into a situation wherein they are deciding a dispute against the party's will, because such kind of damages are prohibited in the arbitration clause itself. They have clearly said that okay, these kind of damages cannot be awarded. I understand that Hague Convention or CEAC Convention, as you are referring, it's a what do you call a totally fictitious situation. A CEAC rule does not provide for exemplary damages. I'm taking just an example. So in such a scenario, the arbitrator will try to find a middle path. There cannot be a situation wherein one can be upheld against the other, because it's simply party autonomy and parties have agreed for both of them. At one place, they have agreed for not awarding the punitive damages. At the same time, they've agreed the seat or a particular type of rules which will be applicable. And by doing that, they have agreed that arbitrator will have the powers to award that kind of punitive damages. So I would say there is no clear-cut answer to this questions, meaning thereby. But usually, if you ask me what is the trend, I will tell you that usually arbitrators will try to find a middle path. They will not award punitive damages, or they will not award that kind of remedy which will make the award susceptible or vulnerable to the challenge in the enforcement stage. Hello?
Okay, sir. Thank you so much, sir.
Thank you. I can take one more question.
Good afternoon, sir.
Yes, sure.
Yes, sir. Sir, I have a question that is there any relation between law enforcement or court and between the consent award?
Sir, can you be a bit more loud?
Is there? Yes, sir. Sir, is there any relation between the enforcement of courts or law and the consent award?
Enforcement of?
Enforcement or law and the consent award.
Is there a difference between?
I'm writing so in the chat box.
Basically, you are saying, is there any difference between enforcement? Sorry, I'm not getting. I'm really sorry. Can you type it down?
You can type it out. Muntazi, you can also type your question in the chat box.
No, he can speak if he can. Muntazi, you speak. No, Muntazi, you speak. I will take it after Ahmed's question. You speak.
Am I audible, sir?
Yeah, very well.
So can you please answer my question? My question is that on what grounds the award may be challenged before a court?
Okay. Let me take Ahmad's question, then I'll take your question. Okay.
Okay, sir. Okay, fine.
Ahmad, you have sent because we can't see anything.
Sir, I have sent you.
Simra, can you see? Yeah. Is there any relation
sir.
between? He's asking, is there any relation between enforcement of award and consent award? Does the consent award also have to be enforced? Okay. It's a good question. Okay. So he's talking about an award which is a consent award. Now, what is a consent award? Consent award simply means that during the arbitration proceedings, parties have agreed that we don't want to fight any longer. Let's go for a settlement. And then in that situation, in addition to signing a settlement agreement, they also they also agree for an award which is based on consent, meaning thereby wherein they go to the arbitrator and tell the arbitrator that okay, boss, this is what we have agreed. We are consenting you to pass this award. Now his question is whether such award needs to be enforced. Ahmed, the answer is yes, it needs to be enforced, meaning there, and why it is so, because if you will not enforce the consent award also, because in consent award you will appreciate the fact that there will be certain commercials which will be agreed between the parties. The parties must have agreed that okay, I will pay you this much, you will pay me this much, and that's how they must have consented. So in order to get the fruits, in order to get the sanction of the court, this needs to be enforced as well. So the enforcement mechanism will be same, and the very fact that it is called consent award makes it enforceable also. So it is enforced in the same manner. Okay. Now coming to Mutazir's question, he is asking on what grounds an award can be set aside. So these grounds are given, Mutazir, in section 34, which can be of any type. Like there are 4 or 5 types. The most famous ones are public policy. Now, what is a public policy? Anything which can shock the conscience of a normal person in India, meaning which is blatantly against the common law of country. There are certain facets of that is public policy. So if an award is against the public policy, or if the appointment of the arbitrator is against the agreed procedure between the parties, or the arbitrator has gone beyond its jurisdiction or beyond the arbitration agreement. So all these, in all those 5-6 circumstances, an award can be set aside. These are given in section 34, which is in itself a whole Bible.
Okay, sir. Thank you, sir.
Yeah. I'm so sorry, because of this connectivity issues, I have taken less questions, but if time permits, we can take one more if there is any.
Sure, sir. Thank you, sir. We'll definitely take one more question if there's any.
Yes, Samriddhi. Yes.
Good afternoon, sir.
Hi.
So it was really nice to hear you. There's one question from my side. It's twofold actually. Like, how long does it take to generally enforce an award? And if there is an objection, so we can challenge it, of course, but will it not prolong the process, and will it not again oppose the actual meaning of arbitration or the ADR per se, that it's not giving a speedy resolution like that?
Yeah, Samriddhi, it's a very good question, and this has been in deliberation. This has been discussion that there has to be a time limit within which a Section 36 application should be decided. I think Tariq sir has joined us. I'll quickly wrap up. Hello, sir.
Hi, how are you, Ananya?
I'm good, sir. How are you?
Good. Pleasure meeting you. Please continue.
I have just one question, sir, and I'm leaving just after this. Yeah. So basically, see, Samriddhi, there have been discussions on there should be a time bar within which this Section 36 application should be decided. However, right now, as of today, we do not have the time limit. Usually, it takes like a good amount of time. I would say there will be like a rejoinder or reply filed by the opposite party. although there is minimal judicial intervention according to Section 5 of the Act, but still it takes some time for the awards to for you to see the real color of money. However, this time is relatively less as compared to what we used to have before this automatic stay regime, because at that time, technically you have to pass the muster of Section 34 before you can actually file Section 36. So this time limit, time procedure, the time prescribed is relatively less now because of this amendment, I would say.
Thank you so much, sir.
Thank you. Thank you.
Thank you so much, sir, for your presence and for your knowledge. It was great hearing from you.
Thank you, everyone. Thank you.
Thank you, sir. So now we have Tariq sir with us. So Mr. Khan, that means Tariq sir, is enlisted in the Forbes Legal Power List 2020 to 2021 as one of the top individual lawyer, youngest BW Business World Legal 40 under 40 2020. He has featured in Fortune 500 magazine for authoring the bestseller book on the rise published by the Universal Law Publishing and imprint of LexisNexis. Sir has been recognized as an arbitrator expert by SCC Online and is also qualified to the conference round of Judge Advocate General, Indian Army. Is skilled in international and domestic arbitrators, MSME disputes, writs, commercial, employment, insolvency, and bankruptcy laws. He has represented some of the biggest global players in various disputes, including construction, supply, joint venture, oil and gas, infrastructure, and renewable energy space. Also represented leading domestic players in high-stake project disputes involving issues relating to defective works, breach of contract, loss of profits, liquidated damages, prolongation, escalation, delay, indemnities, and illegal termination of the contract. Sir has handled arbitrators under SIC, that is Singapore International Arbitration Center rules, International Chamber of Commerce rules, Delhi International Arbitration Center rules, Indian Council of Arbitration rules, etc. Experienced in handling arbitration-related litigation like the appointment of arbitrators, injunctions, interim reliefs, removal and substitution of arbitrators, challenging of arbitral awards, informants of awards, etc. in various courts of India. Sir is invited to speak in various law conferences and events by Domestic Bar Association, Law School, Alternative Dispute Resolution Centers, among other organizations. He also teaches arbitration as a guest faculty for the past 6 years in some of the prominent law school of India. Sir has more than 50 publications to his credit in various journals, magazines, and popular legal news portals. I would like, sir, to address the gathering with the scope of institutional arbitration in India.
Thank you, Simra, for such a lovely introduction. And thank you, Lloyd. It's always a pleasure, to interact with students from Lloyd. I've had a very long association and affiliation with Lloyd Law College, thanks to Salim sir, and now Saurabh, who is taking the torch forward and who has been very kind to invite me to interact with my young friends. At the outset, I would like to congratulate you for taking this initiative and for coming up with something interesting, exciting, and taking up initiatives to institutionalize arbitration in India and to promote the ADR culture. So it really makes me happy. This is exactly what I like and what I believe in. And rightly so, because parties as well as lawyers, young law students are now fed up of traditional court system. And of course, they prefer ADR, arbitration and mediation, owing to various benefits that it entails over litigation. And all of us really know that arbitration and mediation have become the first choice of dispute resolution, at least in commercial disputes. But there are certain things in India, at least, which are, criticized internationally, that why arbitration is not picking up and why arbitration is not becoming a hub of, India is not becoming the hub of arbitration. one of the most important reason is that most of the arbitrations in India are still ad hoc arbitrations. And there's a need to institutionalize arbitration, which was felt, due to which amendments were brought in. If you recollect, 1996 Act is the act which gives the framework of arbitration law in India. The law was amended for the first time in 2015. After the amendment, various changes were made, of course, and it became really, really positive. For instance, what Ananya was just talking about, the automatic stay era was done away with, and there was no more automatic stay on the execution of the award, which was a very positive step to ensure that any person who is a decree holder or who gets an award in his favor should not be deprived of the fruits of the award. And that was the logic why they said that, look, now there's not going to be an automatic stay merely because you have filed a 34 petition. You will have to move a separate application under section 36(2), and you will have to seek a stay on the operation of the award, but the court is going to impose certain conditions on you. The most common one being deposit the amount so that the decree holder can withdraw that amount, subject to furnishing some kind of collateral security. Now in 2019, new amendments were brought in, wherein Arbitration Council of India was introduced for the first time ever. They said that Arbitration Council of India will come up. It will institutionalize India in the sense that the arbitration center, mediation center, all of them will be accredited. Ratings will be given. Arbitrators will be, the performance and all will be seen. So the idea is to make sure that India becomes a hub of arbitration by making the arbitration mechanism in India as a whole robust. Now, how do you make arbitration in India robust merely by institutionalizing arbitration? I think a few years ago in one of my articles, what I had done, I had given certain suggestions why I think arbitration has not been able to pick up and why India is still lagging. Why, if you look at our neighbors like Singapore, Dubai, Mauritius, Malaysia, they are becoming a hub of arbitration. Dubai and Singapore, for instance, are the leaders, I guess. And even though we joined the convention much, much earlier, Singapore became a signatory much later. We were one of the first few countries who joined the convention. So the answer to that question is that most of our arbitration are ad hoc. Now, as you know, that ad hoc arbitration is an arbitration where there is no institution which is involved. No arbitral institution is going to supervise, no arbitration institution which is streamlining the whole process of arbitration. Now, what are the advantages of institutional arbitration, and why should you consider going to an arbitral institution and not having an ad hoc arbitration? So as you know, the whole purpose of arbitration is to reduce court interference. And why? Because if you go to the court, you do not know when are you going to come back. So the idea is to minimize the court interference, and that can only happen when you have an institution with you which is resolving the procedural issues. Now, how a center like ours, International Arbitration and Mediation Center, is going to help you in making arbitration more robust and improving the image of the country as a whole. So as you know that every institution has its own set of rules. Now, these rules are designed in a special manner to cater to the needs of the stakeholders. Now, if you go to IAMC website and you see our rules, you will see that the rules are taking care of each and every procedural issue that may arise, which is not provided for in the Act. So at least an arbitration that is going on under our rules, we will make sure, because we have a governing council of experts, international experts, who knew that what are the possible or plausible issues which may come up, and to avoid them by making a proper, comfortable rules which can be implemented easily. Because rules you need for adopting a procedure, even the arbitrator need guidance, on various fronts, that how to proceed, what should be the next step, how evidence should be recorded, how confidentiality provision should be ensured, how pleading should be filed, what should be the way of request of arbitration. So it's a structured, streamlined, formal, professional manner. And rules make it very, very, convenient for the parties, because the institution acts as a bridge between the parties, lawyers, and the arbitral tribunal. So basically, institution is supervising the whole arbitration and to make sure that it is happening efficiently and in time it is finished. So something as basic as following up from the rules, because there are case managers who look up to the case and they are all experts. They know what are the next steps, how parties should comply with deadlines, then to provide whatever information is required by the tribunal. Then rules make it very easy. And plus fee and all is regulated. Appointment of arbitrator, for instance, you don't have to worry about who should be my arbitrator. The center has its own list and you can get people, experts as per the need of the matter, considering the nature of dispute which is involved. The other issues that are taken care of is the procedural issues. If you do not go to an institution, for every small procedural issue, you're going to the court. If you want to get an arbitrator appointed, you go to court. If you want to challenge an arbitrator, you go to court. Section 11, Section 14, Section 15, Section 12, Section 13. These are the provisions you keep approaching court again and again. But the good thing about an institution is that all these procedural issues are addressed by the center itself. So if you come to IAMC for an arbitration under IAMC rules, if you want to get an arbitrator appointed, we appoint an arbitrator for you. If you want to challenge an arbitrator, we do that for you. We give you a new arbitrator and we see your application. Now you're saving a lot of time on these procedural issues because we are making sure that procedure is quite efficient and quite convenient for the parties. So I think that's one reason why institution can make a great difference in conducting arbitration, to finish arbitrations in time, to make them more efficient, and to serve the whole purpose of arbitration, which is minimum judicial interference, and which is the ethos of Arbitration Act at the end of the day. So I personally feel that it's very, very important to institutionalize arbitration in India. That's exactly what the Sri Krishna Committee also recommended in the report, that the reason why arbitration is not able to, India is not becoming a hub of arbitration is because we are still following the old traditional ad hoc method of dispute resolution. Whereas it is time that we need to institutionalize arbitration in India, to come up with more institutions, to ensure that, institutions are improving the quality of arbitrations in the country, to ensure that they are also improving the quality of keeping a good quality and credibility of the arbitrators. Because, if an institution has a good credibility, you'll be happy to go to the institution to get your matter resolved. So all in all, I think it's a very important step that it's high time as stakeholders, we do understand that, we must encourage institutional arbitration and say no to ad hoc arbitration. And the biggest issue with ad hoc arbitration is that arbitrators were charging whatever fee they wanted, and there was nobody to look at it. And everything was, there's no record keeping. People are just booking venue themselves. Everything is being done in a very, informal and very different, unstructured, unorganized manner. At least with the institution, you get all the facilities in place, all the technology. Like, for instance, in virtual meetings, many arbitrators were not keen on taking up virtual meetings. They said they're not comfortable with the platform. So at least if the center is there, the center can provide all the platforms, Zoom, WebEx, etc., and to make sure that it keeps going on and that it doesn't stop at any point. So I can speak for hours, but unfortunately, Saurav has restricted me to 10 minutes. So I think I'll have to stop. But if you have any questions, I'll be very happy to answer. But I'm always very happy when I'm interacting with students of Lloyd. I want to place that again on record. I'm just very, very happy to interact with you all. Thank you.
Thank you, sir. Thank you. First of all, thank you for joining with us again. And so I would like to take a bow for introducing you. We missed one line, that Tariq sir is mostly known for the motivation, the inspiration for young people, for young law students, as we are from Lloyd. It's not, I have seen, it's not from Lloyd, it's from Jamia, it's from any other university that you keep motivating law students. So I'll be also happy if our law students or the participants of LEAP or anyone who will see this video later on, they will connect you. And I want them to experience the same which I had experienced throughout my last 3 years that I have been connected with you. And we discuss about the vision of India and Indian governments about the institutional arbitration. So I have been experiencing it. Now I would like to request all of the participants, first they will come up with if they have any doubts or question about institutional arbitration. And as we are for the competition which is specifically to culture and promote institutional arbitration in India. So it is designed, and as Ajay Rav sir, as a first guest of a speaker, he had joined and he said that yes, it is the most necessary step. That first, this is the one kind of activities that we are doing to promote arbitration education in India. So this is one kind of program what we are doing. So I will request the students if they have any doubts or questions, they first interact with Tariq sir, and then I will be taking up. Thank you. Thank you, sir.
Thank you, Saurav. Do we have any questions? Or I was too clear that everybody understood what I said? Okay, so there are no.
There's a question in the chat box.
Okay.
If you allow me, so I can read it out.
Absolutely, but why the person is not unmuting and speaking? But anyway, I don't mind whatever they're comfortable with. That's okay.
Yeah. So the question is, sir, as you said, Indian prefer ad hoc arbitration. So can you tell why is this tendency there? Also, advantages of institutional arbitration are known to all. Still, this trend is going on. Like everyone knows about the advantages, but still the thing is going on of ad hoc arbitration.
Unfortunately, people are not aware. I would not agree that everybody is aware. Awareness is the major issue. Many people that I know, because see, many people do not even know about arbitration, forget institutional arbitration. Normally what happens is when you go to a layman, they only think of court as the right platform to get their disputes resolved. They do not know what arbitration is. And if they know arbitration, they do not know what institutional arbitration is. In my center, as a registrar of an international arbitration center, I have also felt that many people, many educated people, and some very senior people have asked me what is arbitration. Sometimes they come and they say, okay, what do you do? So I think awareness is a major issue. I think we need to educate them. It's our duty. And all of you as stakeholders, and Saurav also and I had discussed on various occasions what steps we should take, what can we do as students. For instance, this is one such discussion. But unfortunately, there are not many people who are listening. We are about 40, 45 people. Now, the idea is to disseminate information and to tell people that, look, these are the advantages of institutional arbitration. You get an institution on board, you make your life easier, your arbitration becomes very convenient, and it is easier to resolve your disputes quickly. So, we need to educate people. And it's not their fault. It's perhaps somehow, I think it's my fault as a stakeholder that I'm not able to, educate people around me. And all of us should introspect where we are lacking, why we are not able to educate people, why people do not really choose institutions, why they don't have the faith in institutions. And honestly, for the longest time, we did not have a lot of institutions. People look for credibility and a name. If you look at SIAC and ICC, they were very reputed institutions since forever. And parties would prefer, but not the Indian institutions. So I think there is something which we could not do, which we were supposed to do, but hopefully the trend will change, and hopefully India will start becoming the seat of arbitration. People will start coming to IAMC, and I think that's what we should do.
Thank you so much, sir. Thank you for your answer. Is there any other question?
Yeah, I heard a good afternoon, but I don't know.
Good afternoon, sir.
Yeah.
So just wanted to know from you the current scenario with regard to consolidation of arbitration in India, and what, I have read that Indian courts play a major role in consolidating arbitral proceedings. Does it take away the party autonomy principle from the parties?
That's a very pertinent question. See, party autonomy obviously will be taken away, because if you're consolidating arbitration proceedings, there are two ways in which you can consolidate arbitrations, okay? One is that parties are in agreement and they say, okay, we feel that, these arbitrations are evolving out of a similar contract, or probably nature of disputes are similar, parties are same. Let's just consolidate it before the same tribunal so that there's no confusion. Because what will happen if different arbitrators are appointed, evidence is being given multiple times, different arbitrators may have a different mindset. So always better to have a one-stop adjudication of dispute. So have it before one tribunal. But mostly it is done only when parties consent. I have not seen many cases where a party said, no, I do not want consolidation, and courts have gone ahead. But even if, of course, party autonomy sometimes is compromised, but if the court feels that, look, it is important, it is necessary, and one party is able to establish why consolidation is important, then the courts have advised that parties can place it before the same tribunal. And here institutions play a very important role. At least in our rules, if you get time, you go through it and see what are the provisions we have incorporated for consolidation of arbitration proceedings. The grounds remain the same, that the dispute must emanate from similar nature of transactions, similar nature of contracts, etc., so that it is easy to do one arbitration instead of multiplying the proceedings and increasing the cost and making it very inconvenient. So that's the whole idea.
Thank you, sir.
Thank you very much.
Ayush, do you have a question? You can ask.
Good afternoon, sir. My question is bit different from what the topic is. My question is in litigation, the common people, if the matter is not that big, if the matter is small, or the common people who doesn't know much about the arbitration, then while he approach the arbitrator, means the arbitrator itself, while he took the matter, if the matter is not that big.
Sorry, I couldn't follow. Can you repeat again? I'm so sorry, Ayush.
So if the matter is not that big, means amounts are
okay.
Yeah, it's a small matter. First of all, that while a person go to the arbitrator, and while arbitrator itself will take up that matter. First question is that, and the second question is for a common people, who is not educated, who doesn't understand all these nitty-gritties of the contract and all that. While he even if he know about the arbitration, but he can't do much about it. Then while he'll approach an arbitrator. Second question is that.
Okay. So answering your first question, see, I personally feel that in small disputes, you're right. If the dispute is of a very small amount, arbitration, I don't think is a great idea. You better do something like MSME disputes, micro, small, medium enterprises, where there are facilitation councils that are taking care of such matters. Because I'm assuming that usually it's a micro or a small entity which has smaller amounts. Or you can consider doing mediation, because mediation is the best forward to finish such disputes, and not going to, because it's cheap. You don't have to pay any much. So in arbitration, yes, you'll end up paying a lot. So, or perhaps you may explore the possibility of an ODR platform. Saurav is running a platform of that nature, so he'll educate you more. So I think in smaller disputes, I think ODR and all can be the viable choice. That's my take.
So if no one has any further question, then I will be taking this opportunity to ask small doubt.
Yes, please.
So it's always for me to give something to the students, and then like in your speech, you emphasize on the process, in the procedural issues or the institutional arbitration, how much it is necessary to like facilitate from an administrative side, or from a center side, from an institution side. So while they will be competing in an institutional arbitration format, while doing for notice of arbitration, drafting notice of arbitration, drafting response to notice of arbitration, and all other draftings for this competition, what are the key points that they need to take care or they need to consider? If you kindly please highlight.
Okay, that's a very, very pertinent question, Saurav. Thank you for asking. See, arbitration at the end of the day is all about documents. Arbitration is, you win an arbitration either on facts or documents. what documents you have gone through, and contract, of course. Contract is of utmost importance. So if there is a contract involved, you need to understand that arbitrator is a creature of an agreement. He derives all his powers, or she derives all her powers as an arbitrator from the contract itself, because the contract gives you the right to appoint an arbitrator. So contract supersedes everything. For any arbitrator or for any arbitral tribunal, contract is the Bible that he or she has to follow. So rely on the contractual provisions. That is what was agreed, and that is what arbitrator has to abide by. So strongly rely on the provisions of the contract which are in your favors, even in your drafting. The second thing that you have to do is your drafting has to be like a story. If a dispute has arisen, you have to start from day one. You can't just start from the dispute. And you have to end till the story that it is today when you are sending the notice or when you are drafting any document. And while drafting, you have to be very careful that language has to be super simple, clear, lucid, concise. Grammatical errors should not be there. Syntax, proofreading, these are a must. Proofreading always helps, and editorial changes are always welcome. Make sure that your notice is clear for anybody who reads it for the first time. Should be able to understand anything, and it should look like a story. Be a good storyteller, and write the relevant provisions of the contract. Do not forget to mention the arbitration clause in the agreement. Do not forget to comply with the requirements of the arbitration clause. Whatever it says, that has to be complied with. If it says that the seat is Delhi, the seat shall be Delhi in your notice. If it says that mediation should be exercised first, then you first say that, I have amicably tried to resolve the dispute, but it is not happening. All the efforts have failed. So it should look that you have tried that possibility and your notice is not premature. The other things that you have to emphasize on is the documents. Whatever documents have been given, you should be a master of the documents, because you have to use those documents in your favor in every arbitration. Last but not the least, the law on arbitration and the judgments are the most important. So you should know the procedure. Highlight on the procedure. What is the procedure which is followed? How do you go about it? Procedure is the most useful and the most important exercise, because this will help you in your real life also. Even though this is just an exercise which the college is doing, but when you become a lawyer, you will be doing arbitrations. You will have a first-hand experience of following the procedure in an arbitration. So I think emphasize too much on the procedure which is being followed. Go step by step. You should know where it starts, how it moves. And what you can do is you can watch some of the videos, how people are doing arbitrations, what are the steps that are involved in an arbitration. So I think all of those things should help you. Unless somebody has any specific question, I think that's all I have to say.
Good afternoon, sir.
Good afternoon.
Sir, firstly, I want to congratulate you, because last time we interacted with you, you were the senior partner of Advani & Co. And this time you are the registrar of the AIMC. So my heartiest congratulations to you. I don't have any particular question as such. I just wanted to ask, what points do we keep in mind while pleading or while preparing an arbitration case as a counsel? But I think that has been answered more or less by Saurash's questions. But if you can give some insights, that would be helpful.
Thank you, Akshat. Thank you for your greetings and wishes. I'm very happy to see you. I think, yes, as a lawyer, as a counsel, as an arbitrator, I think one thing you need to be very careful about is language. And by language, unfortunately, I mean English also. Because, I'm somebody who has been telling people that language is just a mode of communication. It is not a measure of somebody's talent and knowledge. Because I think content is more important. What content you say, what weightage your words have, I think that's very important. In fact, I have given I've written a article which will be published, I think, in a day or two, wherein I have talked about legal writing, the importance of legal writing, the importance of drafting and research in the life of a lawyer. So I personally feel that reading, writing, research, these are the three keystones in the life of a lawyer or any counsel. So the more you read, the more you know. The more you know, the more you can write. And you can only write when you research more. So first research, then read, then write. And research is very, very important to not just get lost in the wrong direction. When you're researching, you have to stick to the point. You need to identify the current issues which are going on. And you need to start reading judgments as much as you can. When you read judgments, you start understanding the mind of the judge, and you start thinking like a judge. You start talking the law. And believe me, it has happened with me. I'm somebody who didn't understand English at all until my first, second year of law school. Today, whatever I speak, it's all coming from some judgments I may have read. So that has played a very, very important role in my life, and it has helped me in shaping up my career and helped me grow as a person and as a professional. But believe me, one thing you have to always remember is that you have to be honest to the court, and you have to work hard. There is no substitute to hard work. And keep reading, keep learning, keep growing, and follow your passion. That's extremely crucial. Because if you follow your passion, and I was reading somewhere yesterday, someone said that when you are looking for a job, you look for a job as if you would have chosen it when you were not looking for money. Like what you would have done if money was not to be given to you in return. What job you would have chosen. That should be the criteria to decide your, job, work, career. Money should not be the criteria or consideration. That's the bottom line. I hope I've answered your question, Akshat. Thank you.
Definitely, sir. Thank you.
Thanks. It's a Saturday evening. I think all of you must be now willing to go and enjoy with friends. I'm sure once nowadays webinars have become quite boring. So I'm not sure if Saurabh, what do you think?
No, sir. Actually, I am not giving them any holidays for they had just come over after the exams, and now they are doing this competition. After this, they are for any mooting competition or mediation competition or mooting anything. They are engaged because sir, director sir, how much director sir is passionate about ADR competitions and mooting competitions and all. So he always wants that the sincere students shall be engaged, and all who are here on holidays, they are sincere, and all who are not. Yeah.
All these people who are here, I hope they win something soon, and then they give me also credit about their success. But we attended one of the sessions by Mr. Tariq. I'll be happy to be tagged on LinkedIn. So please win good trophies for the college and also give me some credit which I don't deserve, but I'll be happy.
Yes, sir. Thank you, sir. I'll be happy to invite you for our further proceeding that we take under LEAP. And once we are coming up with elimination rounds. In one case, there will be client counseling, and then there will be mediation negotiation and the arbitration. So that will be in one case. And then we'll start with writing notice of arbitration and then response to notice of arbitration till enforcement of arbitral awards. So that will be also a mock-up. So no other moves, or as we discussed, that no other moves or no other competition of any arbitration is happened like this format. So we are coming up with this program, which is called Lloyd International Arbitration Advocacy Program. We are not taking it as a competition only, but yes, we also provide the training sessions, which will be required at every step. So we'll be trying to look forward your suggestion and your guidance, as you are always giving me personally and to the Lloyd Area Center. So thank you, sir. Thank you for your blessings and your precious time. Thank you, sir.
Thank you, Saurav, and thank you, everyone. It was really nice to see you all, and hope to see you in person soon. Thank you very much, and all the best.
Okay, so if there is any other questions by the participants, then you can raise your hands or drop your questions in the chat box. Your questions will be addressed.
So as we can see, there is no further questions. I would like to inform you guys that by today or tomorrow or day after, you will receive an email which will provide you guys with the further instruction on how you should, how the entire program will happen, and the problem, the mood problem, the case study which you will receive in that particular email. And also, if you guys have any further questions regarding to this, you can ask. So, okay, we will receive the cases on Wednesday. And I think that's about it. And that's the information that I have to give you guys. So we will also have a meeting on Saturday with all the participants of LEAP, where we'll be discussing on any questions that have come across, you guys come across, and all the clarifications will be given on Saturday. And yeah, and I would request all the participants, please keep up to date, keep themselves up to date with the mails that are coming, and please check them every day regularly, that you don't miss out on any important mail regarding the further instructions. So I think that's about it. So let's call it a day, and we'll see you in the next meeting. Thank you, guys.
Thank you so much, everyone. You may now leave the meeting.
Thank you.
And if there's any question, I don't really think there's any other question. So that's all.